Thank you very much, Justice Stewart. Very kind. Ladies and gentlemen, it's a great honour to have been invited to deliver this year's Sir Harry Gibbs Oration. It's also something of a challenge. What does one say to such an august gathering as this that's relevant and interesting and yet sufficiently uncontroversial as not to be imprudent? As you may glean from the title, I've sought inspiration in Sir Harry Gibbs' legal conservatism. Views may differ as to whether that's interesting, although I hope you find it to be so. But on any view, I suggest it is at least as relevant in this postmodern era of relativism as it was in the epistemically more certain times in which Gibbs evolved it. Next year will mark 50 since Harry Gibbs was appointed to Justice of the High Court, and 1 year short of 40 since it became its 8th Chief Justice. It's been said that the court over which he presided was a bridge between Barwick Court's conservatism and the Mason Court's progressivism. The reality, however, is more complex. Certainly, Gibbs steered the High Court away from the Barwick Court's laissez-aller approach to tax avoidance and towards a more purposive approach to the construction of revenue legislation. In that sense, it could be said that Gibbs was more progressive than Barwick. But in other respects, particularly Gibbs' more states' rights-based approach to federalism, Gibbs tended to be more conservative than his predecessor. Gibbs has been described as a legal conservative by his detractors as a mark of apparent disdain of what they perceive to be his lack of jurisprudential innovation, and by his admirers in recognition of his insistence that the law is more important than one's personal preferences and that the hard logic of legal principle should not be overborne by sociological considerations. Looked at objectively, the latter assessment is undoubtedly the more accurate. As one of Gibbs' most informed critics wrote, Gibbs had in the highest degree two qualities essential to a great judge: total commitment to legal principle and a positive inability to compromise once persuaded what the law requires. But that accolade even is not sufficient to reflect the full extent of Gibbs' contribution. Gibbs was a Queen's man, an influential advocate of the great advantages of Australia's system of constitutional monarchy, and he was a distinguished member of the Privy Council. He was also a strong adherent to Privy Council precedent and more generally a strong proponent of what he regarded as the special worth of English authority. As he observed in an address to the Queensland Bar in 1983, although it had become fashionable at that time to comb the law reports of common law countries and to treat decisions of English courts as entitled to no greater deference than those of other common law jurisdictions, it was to be remembered, he said, that not only that England is the source of our law, but also that most of the judges of the English courts have a distinction in the law which is not always uniformly attained on benches elsewhere. Although Gibbs was a Queen's man, however, and to some extent also an Anglophile, he was also seized of the great importance of Australia's increasingly independent post-war legal identity, and he embraced it. In that respect, he was not unlike Barwick, albeit that in some other respects each man was the antithesis of the other. In 1968, the Commonwealth Parliament passed the Privy Council Limitation of Appeals Act, which restricted the right of appeal from the High Court to the Privy Council to matters in which the High Court's decision was given on appeal from a decision of a state Supreme Court otherwise than in federal jurisdiction. 7 years later, the Privy Council Appeal Act of that year extended the restriction to all decisions of the High Court, but it was not until the passage of the Australia Act a decade later that the rights of appeal directly from state Supreme Courts to the Privy Council were finally abolished. In the meantime, in 1973, in the midst of the Bjelke-Petersen's government resistance to what it perceived to be the improper encroachment of the Whitlam government's policies on state rights, the state of Queensland enacted the Appeals and Special Reference Act of that year. By that legislation, Queensland purported to provide that it should be lawful for the Attorney-General of Queensland to apply to the Supreme Court of that state for a certificate that any inter-se question or matter of the kind specified in the Act was one which, by reason of its great importance, should be referred to the Privy Council, whereupon it would be. In effect, the Act was designed as an end play to get around the abolition of appeals from the High Court to the Privy Council on inter-se questions. Understandably, I suppose the Commonwealth challenged the validity of the legislation in what came to be known as the Queen of Queensland case. Gibbs delivered the leading judgment He concluded that the legislation was invalid because it would be contrary to the inhibitions which, if not express, are clearly implicit in Chapter 3 of the Constitution. Notably, His Honour added that, subject to special considerations, the limitations of Commonwealth and state powers having a peculiarly Australian character and being a fundamental concern to the Australian people should be decided finally in the High Court. In light of Gibbs' sometimes states' rights-based approach to federalism, his judgment in the Queen of Queensland case might not have been what was expected. It was, however, entirely consistent with his later judgment in Viro and the Queen that, in view of the abolition of appeals to the Privy Council, the Privy Council was no longer at the apex of a hierarchy of courts of which the High Court was a member, and it was consistent with the fact that throughout the decade that separated the enactment of the Privy Council's appeals from the High Court Act in 75 and the enactment of the Australia Act in 86, Gibbs was publicly highly critical of the continuing existence of rights of appeal from state Supreme Courts to the Privy Council. For example, in his speech on the estate of the Australian judicature in 1981, he forcefully re-emphasised concerns earlier expressed by Sir Garfield Barwick in addresses in 77 and 79 about the existence of the potential for conflict between jurisdictions and the embarrassment and inconvenience likely to result if state courts were faced with conflicting decisions of the High Court and the Judicial Committee. He branded the right of appeal to the Privy Council as a relic of empire, which he said was now anomalous and anachronistic. And he said that although he would in many ways sincerely regret the breaking of the tie with what he called the nursery of our laws, the present situation could hardly continue for long. In another speech given in 1983, Gibbs criticised the fact that some appeals from state Supreme Courts to the Privy Council as of right, in his view a test based on the amount of money at stake, was not satisfactory, and what he described as the obvious alternative was to provide that no appeal should lie otherwise than by grant of special leave. A year later, he deprecated the continuing existence of the right of appeal to the Privy Council as a jurisdiction in relation to Australia that was difficult to explain to foreigners or to reconcile with our pretensions to independent nationhood, and he once again emphasised that year that he felt it necessary to point to the difficulty and inconvenience of the present situation, because progress in the matter has been so slow that one feels that not all of those concerned understood the urgency of the need to close that chapter of our judicial history. Nor was the abolition of appeals the only component of Sir Harry's quest for change. For at the same time that he was striving for the abolition of rights of appeal to the Privy Council, he was also pushing very hard for the divestiture of significant parts of the High Court's original jurisdiction and for the introduction of the then controversial requirement of special leave to appeal to the High Court in virtually all cases. In that respect too, Gibbs was at one with his predecessor Barwick, with whom those proposals had originated. Barwick had first formulated the idea of a special leave requirement when he was serving as Attorney-General in the early 1960s as part of his plan to establish a federal superior court. Following Barwick's appointment as Chief Justice in 1964, he continued to advocate for the idea. He considered that the right of appeal to the High Court should be by leave only in order to ensure that the High Court of Australia may move into a new phase of development as the court mainly of ultimate resort in Australia. Gibbs was of the same view, and following his appointment as Chief Justice in 1980, he campaigned vigorously in support of it until his objective was finally achieved in 1984. As some of you will recall, doubtless, a large section of the legal profession were opposed to that change. Many did not consider that it was either necessary or desirable to abolish rights of appeal to the Privy Council, and for some it presented as paradoxical that even as Gibbs was striving for the abolition of rights of appeal to the Privy Council, he was also campaigning hard to make appeals to the High Court more difficult to mount. The extent of the profession's opposition was evident in an editorial published in the Australian Law Journal upon the passing of the Amending Act. After referring to some remarks of Senator Peter Durack, the editors continued that the citizens of this nation have thus been deprived of a traditional right of appeal to the High Court as of right, regardless of the cogency of the arguments for that measure, and this deprivation has certainly not been received with enthusiasm by the legal profession as a whole in Australia. Gibbs, however, was entirely unmoved. In his 1984 address to the Lord Denning Appreciation Association, he stated that while the Law Council of Australasia was strongly opposed to the change, fortunately the Attorney-General supported it and introduced the legislation which had passed that year. Likewise, in 1985, in his State of Judicature address, he stated that while some sections of the bar had opposed the change and perhaps still regretted it, it had been necessary to prevent the High Court from being overburdened with what he called cases of no real importance, and logical because in a well-ordered judicial system, it's enough to allow one appeal as of right with the safeguard of a further possible appeal by leave in appropriate cases. Unlike Barwick, however, Gibbs was not at all enamoured of the idea of a federal court. Initially, his objections appeared modest. While accepting the commission as Chief Justice, he noted that in some respects the boundary line between the jurisdiction of the federal courts and those of the state courts remained ill-defined, and he observed that it was to be hoped that the Commonwealth and the states, acting in conjunction with a view to advancing public interest rather than their self-aggrandisement, eventually would be able to integrate the federal and state courts into one harmonious system. In later speeches, however, his observations became more strident. He referred to the establishment of the federal court as unnecessary and described the then frequent jurisdictional clashes between the federal court and states court as reminiscent of the Middle Ages. He commented that the scope of the accrued jurisdiction, which as many of you will know is a technique by which the federal court greatly expanded its jurisdiction, had been said to be a matter of impression and practical judgment, which he constituted as hardly a precise delimitation of jurisdiction. He also branded the then popular idea of establishing an integrated Australian Court of Appeal, but one which he said which baffles the imagination to discover any good reason why the creation of a new court should assist in resolving the jurisdictional conflicts between two others. Gibbs' progressivism in campaigning for the abolishment of Privy Council appeals and otherwise to ensure that the High Court became the ultimate court of appeal in this country presents in one sense as ironic, in that he continued to have the highest regard for Privy Council authority and considered it vital that, generally speaking, the High Court should continue to follow and apply principles established by courts of requisite authority. But as Gibbs revealed in an address to the Queensland Bar, legal conservatism in that respect was essentially pragmatic. As he said, we could not all hope to match the combined wisdom of our predecessors, and courts which were too prone to overrule their own decisions were likely to lose public confidence. In Gibbs' view, adherence to precedent was particularly important in the fields of commercial, fiscal and property law, so that people might arrange their affairs with some degree of confidence. This is not to say, however, that Gibbs was so conservative as to be inflexible or without the ability to compromise. He was plainly mindful of the need to reconcile the certainty with the attainment of justice in a given case. And he, as he said, well aware that unfairness may sometimes result as much from the application of settled principle as from the application of a principle developed for the first time. Rather than slavish adherence to precedent, Gibbs' technique of judicial reasoning was therefore one of conservative incrementalism, a careful case-by-case approach to the development of principle, as has been said, which enabled new aspects of a given legal problem quietly to be accommodated and the unsatisfactory features of a past decision quietly to be modified. On Gibbs' retirement as Chief Justice in 1987, one commentator wrote that if there were any discernible weakness in Gibbs' formidable judicial armoury, it lay in the field of equity and equitable practice. Given his command of equitable principle as demonstrated more than once during his time on the High Court, the accuracy of that suggestion presents as doubtful. But if Gibbs were at all weak in equity, he was second to none in crime and tort, and ultimately he brought to the process of statutory interpretation a degree of leadership which in large part still informs the way in which the High Court goes about that task. The strength of Gibbs' adherence to precedent and his predilection for incrementalist development of legal principle were instrumental in his achievements in each of those respects. In crime, Gibbs regarded adherence to precedent as necessary to secure what he described as that essential element of certainty which in civil law countries is given by the codes. But he was also conscious that compromise is sometimes required in order to achieve certainty. His judgment in Varro and the Queen demonstrates both points. It concerned the doctrine of what was called excessive self-defence manslaughter and necessitated reconciling previously expressed divergent views of the High Court in the Queen and Howe and the Privy Council in the Queen and Palmer. As is now generally accepted, the doctrine of excessive self-defence manslaughter was first articulated by the Victorian Full Court in the mid-1950s in a case called Mackay. In the following year in Howe, the High Court approved the doctrine, and thus it was authoritatively established. Thereafter, presumably, it would not have been questioned were it not for the fact that 13 years later, in 1971, the Privy Council rejected it in Palmer. It held, contrary to Mackay and Howe, that the correct statement of the law was that self-defence either succeeded and thus resulted in an acquittal, or if the amount of self-defence was excessive, the defence was to be rejected. 7 years after that, in 1978, it fell to the High Court in Viro to determine whether to follow its own previous decision in Howe or to follow the Privy Council's more recent decision in Palmer. Given that Palmer had been decided before the abolition of appeals to the Privy Council, that required the High Court to decide first whether the doctrine of the precedent bound it still to follow that Palmer's decision, and secondly, if it did not, which of the two competing decisions was the correct one to follow. The High Court was unanimous in holding that the abolition of appeals to the Privy Council had secured the High Court's position as the ultimate court of appeal in all cases, and therefore that it was not bound to follow Privy Council decisions. Gibbs in particular emphasised the High Court's new function as the ultimate Australian Court of Appeal, and that it both reflected and contributed to an emerging Australian identity. But the High Court was divided as to whether to follow Howe or Palmer. Justices Jacobs and Murphy delivered judgments which were uncertain in effect. Justices Stephen Mason and Aiken preferred the High Court's previous approach. Gibbs, with whom Barwick agreed, took the opposite view. But ultimately what most distinguished Gibbs' judgment was his concern for certainty of precedential effect. As there were only 3 clear adherents to the holding in Howe and only 2 clearly in favour of Palmer, there would have been a real question of what Viro stood for. But in the passage of Gibbs' judgment that bespeaks his recognition of the need to reconcile certainty with flexibility in order to do justice, he concluded that because the task of judges presiding at criminal trials becomes almost impossible if left in doubt as to what the High Court says on a question of criminal law, and because the view which appeared to have more support than any other was in favour of Howe, he was, contrary to his personal opinion, but in a desire to achieve a measure of certainty, prepared to agree. As a footnote, it may be noted in passing that his view was ultimately vindicated later on in Zekovich, the proposition, when the court, both ended by Chief Justice Mason, concluded that the Howe approach had created so many difficulties that it should be abolished. But that's all since been adjusted again by statute in many jurisdictions. In the law of torts, Gibbs' conservative incrementalist approach to authority is possibly best illustrated by seminal decisions in Caltex Oil and Shattuck and City of Parramatta. Each involved an ancient exclusionary rule that damages are not generally recoverable for economic loss, if not intended or consequent upon injury to a claimant's personal property. And each involved the development of that ancient law to meet changing societal requirements. In Caltex, the question was whether Caltex Oil could recover damages for extra costs of transporting refined oil after a pipeline in which the refined oil would otherwise have been transmitted to it was fractured by the defendant's negligent navigation of a dredge. The claim was purely for financial loss inasmuch as none of Caltex property had been damaged. The only damage to property was to the refining company that owned the pipeline and the oil that was in it. Other things being equal, the ancient exclusionary rule that damages are not generally recovered for pure economic loss, not consequent upon damage to property, would have precluded recovery. But shortly before Caltex was decided, the House of Lords had held for the first time in Hedley, Byrne and Heller that a negligent misrepresentation may give rise to an action for damages for pure financial loss. The issue which was thus presented in Caltex was whether the exclusionary rule had survived Hedley, Byrne, and if so, with what effect. As Gibbs observed, Headley-Burn could have been understood as merely recognising an exception limited to misrepresentations as distinct from negligent conduct. But as he said, that would have been a surprising result, given that it's frequently not easy to distinguish conduct from representation. His solution, therefore, was to hold that while it was still correct to say that as a general rule damages are not recoverable for pure economic loss, it should be accepted that there are what he called exceptional cases where a defendant has knowledge of means of knowledge, the plaintiff individually and not members of class will be likely to suffer economic loss as a consequence of the defendant's negligence, and accordingly the defendant will owe a duty of care. Pointedly, Gibbs added that it was not necessary and that it would not be wise to attempt to formulate a principle that could cover all cases in which such a duty is owed, that it was best to approach by step to the facts of a particular case which came before the courts. In Shattuck, the question is whether a municipal council was liable for economic loss suffered by purchasers of a development property on the faith of a planning certificate in which the council had failed to mention that the property was subject to road widening proposals. One difficulty for the purchasers was that although the House of Lords had held in the Headley-Burn that a negligent misrepresentation was actionable, in MLC and Everett, the Privy Council had limited the duty to persons who carry on a business or profession of giving professional advice. Arguably, the Council did not fit into the category. Extending but qualifying, however, his earlier analysis in Caltex, Gibbs acknowledged that there were three obvious differences between negligent words and negligence acts. The words do not cause loss by themselves, but cause loss because people rely upon them. The people speak less carefully in social and informal contexts than in professional contexts, and that words may be circulated, raising a spectre of indeterminate liability, an observation which pretended much, which has followed since. He also accepted that it was because of those differences that the majority in the Privy Council had limited the duty to people who carry on a profession or business of giving advice. But Gibbs said he found it difficult to see why the duty should not extend to any person on a serious occasion Gibbs considered vice. And on that basis he reasoned that the limitation of the Privy Council should be understood to confine to its context. He concluded that given that from the standpoint of principle there was no difference between a person who carries on the business of supplying information and a public body like the Council, who in the exercise of its public functions follows a practice of handing it out, the Council should be liable. Now, today these approaches to the recovery of damages for pure economic loss are de rigueur, but at the time they were groundbreaking developments. One of the more striking features of Gibbs' reasoning in them, therefore, is the appearance of elements of his judicial temperament that to some extent present as inconsistent. On the one hand, there's a pronounced hesitancy about departing from English authority, and yet at the same time a strong commitment to Australian legal independence. On the other hand, an inclination towards the application of principle unfettered by illogical distinctions, and yet at the same time an unwillingness to venture beyond the particular facts of the case. Lastly, it remains to mention something of a more controversial manifestation of Sir Harry's conservatism, his contribution to statutory interpretation, Section 260 of the Income Tax Assessment Act, the old anti-avoidance provision. 2 decades ago, the history of the jurisprudence surrounding that provision were notorious. Now it's largely forgotten. Suffice it to say for present purposes, therefore, that in effect it comprised 3 stages. The first, which ran between 1921 and 1966, resulted in what was called the predication test that underlay the Privy Council's 58 decision in Newton and Federal Commissioner of Taxation. The second, which began with the appointment of Sir Garfield Barwick as Chief Justice in 1964, led to the repudiation of most of the previous learning on the subject, culminating in a case called Cridland in 1977 in an extreme version of what was termed the choice principle. And the third commenced with the appointment of Sir Harry in 1981, and under his leadership led in 1985 in a case called Gulland to a re-engagement with previous learning and Privy Council authority, and the adoption of a purposive approach to revenue statutes that still holds sway. His judgment in Gulland is controversial because it was widely criticised as an abrupt change in tack and as inferior to what was said to be the more principled, strict legalism of the Barwick Court's approach to revenue law. According to such criticism, adherence to precedent required the High Court to continue to apply a strict or literal construction of revenue statutes, as exemplified in the judgments of Sir Garfield Barwick. It was contended that there was simply no room for the kind of purposive approach that Gibbs' judgment entailed. Similar criticism was also directed at the High Court's later decision in Cooper Brooks Wollongong, in which the Court, once again led by Gibbs, shunned a strictly literal approach to the construction of a provision of the Income Tax Assessment Act, that it was apparent was the product of a mistake in drafting. That decision was characterised by some critics as in effect caving in to the pressure of a groundswell of public opinion against tax avoidance, dismantling traditional learning, and in its place adopting an unprecedented emphasis on statutory purpose. Much of that criticism, however, was misplaced. Properly understood, Gulland represented a return to orthodoxy. Traditionally, the principle of strict construction of taxing statute was not regarded such that one approached revenue statutes radically differently from other statutes. As long ago as 1903, Mr. Justice Barton had observed that this rule of strict construction of revenue statutes, while a valuable caution, cannot be taken as substantially varying the ordinary rules for construing all statutes. Even Lord Tomlin's remark in the Duke of Westminster case, upon which so much of Sir Garfield's jurisprudence of 260 was based, was made in the course of attempting to reject an attempt to treat judicial approval of taxpayers' conduct as a substitute for applying the language of the Act. And it might be thought perhaps that Sir Garfield's many references to the need for unambiguous clarity may more naturally be understood as stating an ideal for Parliament than a principle of interpretation. Likewise, Cooper Brooks reflected long-established doctrine, the principle regarding objects which the legislature is presumed not to intend were capable of displacement by implication as well as express terms, and that a provision like the one in question in Cooper Brooks, which was devised specifically to remedy a particular failing in the law, will obviously be construed so as to ensure so far as possible that the intended remedial effect succeeds. Lastly, Gibbs' emphasis on statutory purpose was not unheralded. As he noted, the difficulties of construction which Cooper Brooks presented had been recognised by Chief Justice Barwick a decade before, and as Gibbs added, it had long been established that where the result of giving words their ordinary effect may be so irrational that the court is forced to the conclusion that the draftsman's made a mistake, the canons of construction are not so unrealistic as to prevent a solution in such a case. Notably, amongst the authorities which Gibbs cited in support of that premise was a decision of the House of Lords of 1877 in which Lord Blackburn had observed that the purposive construction of all statutes had been the law since at least the 16th century. So to conclude, what does it mean to say that Sir Harry Gibbs was a legal conservative? No doubt many things. But based on the matters I've referred to, I suggest four. First and fundamentally, although Sir Harry had one eye cast back to the Australian common law's English origins, he was a man of his time who was seized of the changing order of events and very much focused on the future. His was a form of legal conservatism that allowed him to shape the development of legal principle according to changing societal requirements, while remaining true to the demands of stare decisis. Secondly, in crime, Gibbs' legal conservative implied close adherence to the doctrine of precedent because, among other reasons, he considered that it was vital as a protection against oppression. Yet at the same time, as he demonstrated in Viro, he was ready to depart from precedent when persuaded that it was wrong in principle, and even then still to compromise in the interests of certainty. Thirdly, in the law of torts, Gibbs was prescient in his appreciation of the problems of attempting to lay down broad-ranging prolepses and of the relative advantages of a conservative incrementalist approach to the development of legal principle. The alternative, from time to time favoured by some other common law's ultimate courts of appeal, has arguably not achieved the same degree of consistency. And finally, in tax, and more generally in the process of statutory construction, Gibbs' strong adherence to precedent and incrementalism informed his resistance to what he perceived to be the excesses of strict legalism, and indeed Gibbs' leadership of the High Court's re-engagement with the purposive construction of statutes that is sometimes necessary to achieve the results which Parliament intends. At the time of the enactment of the Privy Council Appeals from the High Court Act, Edward St John, Queen's Counsel, wrote that from now on the High Court must be the great Australian court developing Australian law for the Australian people. As Gibbs himself observed in a speech at much the same time, in Australia the High Court plays a significant part in bringing about a unity not only of the law but of the nation. Although he would have been the last to claim credit for himself, Sir Harry Gibbs, a legal conservative, was one of the truly great contributors to both of those accomplishments. Thank you.